दोस्तों, मैं रोहित कुमार एबनीशो की ओर से आपका स्वागत करता हूं।
The topic that I will discuss today is rule of law, and I'd like to inform you that this topic is not found in jurisprudence books. For this purpose, you'll have to read administrative law books. So today we'll discuss rule of law. This concept, doctrine of rule of law, this doctrine of rule of law has been propounded by Dicey. He was an English jurist, Dicey, D-I-C-E-Y, Dicey. So according to Dicey, the rule of law is one of the fundamental principles of the English legal system. In English legal system, he says, you will find this is a fundamental doctrine of English legal system. That means the English legal system is based on rule of law. In his book, Dicey attributes three meanings to the doctrine of rule of law. The first meaning is supremacy of law. Second, equality before law. And third, judge-made constitution. And we will discuss all three principles in this lecture. The first principle of rule of law is supremacy of law. So he explains what is supremacy of law. Dicey says that the rule of law means the absolute supremacy of law or absolute predominance of regular law, which is opposed to the influence of arbitrary power or wide discretionary powers in the hands of the administration. So supremacy of law means the absolute supremacy of law. It is absolute predominance of regular law. When we say that predominance of regular law, it is always opposed to the influence of arbitrary powers in the hands of the administrator or even wide discretionary power in the hands of the administrator. But here I believe that Dicey is slightly confused between arbitrariness and discretionary powers. Because see, discretionary power is always different than arbitrary powers. Nobody wants arbitrary powers in the hands of the administrators, but wide discretionary powers sometimes are necessary for the good governance in the country. So first we'll need to understand what is discretion. Discretion means choice between two courses of action or inaction. So that option should always be there with the administrator. So it is correct that if you want predominance of regular law, if you want supremacy of law, there should be no arbitrariness. But as Dicey says that there should also not be a wide discretionary powers in the hands of the administrators. But in my opinion, this is not correct. Further, Dicey says that rule of law excludes the existence of arbitrariness, of prerogative or even wide discretionary powers in the hands of the administration. So on the part of the government, there should be no wide discretionary powers and there should be no arbitrariness. According to Dicey, the Englishmen are ruled by the law and law alone. A man may be punished for a breach of law but can be punished for nothing else. That is his very famous statement. In Dicey's words, wherever there is discretion, there is room for arbitrariness. And that in a republic, no less than under a monarchy, discretionary authority on the part of the government must mean insecurity for legal freedom on the part of the subjects. So Dicey says that if you want liberty, if you want the freedom of the people, then there should be no wide discretionary powers in the hands of the government. Dicey describes this principle as the central principle or most characteristic feature of common law. So he says that a supremacy of law is the most important feature of English legal system. It is a most important feature of common law as well. Here I stop for a minute and ask you whether you have any question.
सर अभी तो ये कोई क्वेश्चन नहीं है, बहुत ही बेसिक सा था ये.
हाँ, बेसिक सा ही है ये. The next meaning of rule of law is equality before law. Equality before law we also have in our constitution, Article 14 of the Indian Constitution. Equality before law and equal protection of law to the people. So Dicey also explains why equality before law is so important and how it becomes a rule of law. So this is the second principle of the rule of law, and Dicey also explains this one, and he says that there must be equality before the law or the equal subjection of all classes to the ordinary law of the land administered by the ordinary law courts. He says that, see, there should be equality before the law, and also that all the people should be equally subjected to the law of the land, and all the people should be equally under the jurisdiction of the ordinary law court. So that means there should be no special courts for some people. According to Dicey, in England, all persons are subject to one and the same law, and there are no separate tribunals or there are no special courts for officers of the government and other authorities. So he says that everybody is subject to the same law courts, everybody is under the jurisdiction of the same law courts, and there are no special courts for the disputes between citizens and civil servants, etc. He proclaims that with us in England, every official from the Prime Minister down to constable or a tax collector is under the same responsibility of every act done without legal justification as any other citizen. So he says that the responsibility of the Prime Minister and responsibility of the constable or responsibility of the tax collector is towards the law and law alone, and they are under the jurisdiction of the same law code. So what he was criticizing here, he was criticizing the French legal system of droit administrative. Droit administrative क्या है? Droit administrative है distinct administrative tribunals for deciding cases between the officials of the state and the citizens. तो एक टाइप के administrative courts हैं. Droit administratives are special courts set up by the French legal system in order to decide the cases between officials and citizens. So he is criticizing that system. He says that no, everybody should be under the jurisdiction of the same law courts, ordinary law courts. But again, here also he is not correct. In India also we find administrative tribunals in order to decide the disputes between civil servants and the citizens, educational institutions and the citizens, other employers and the citizens. So that kind of courts are also required because they have got this special understanding of administration. So you have that administrative tribunals, and in France it is also known as droit administrative, which Dicey had bitterly criticized. According to Dicey, exemption of civil servants from the jurisdiction of the ordinary law courts and providing them with the special tribunals is the negation of equality. So he says that if you provide special law courts for civil servants, then it is a negation of equality. What you are negating is equality, and equality should not be negated, he says. Of course, Dicey himself saw that administrative authorities are exercising even judicial functions in England, although they are not judges, and he therefore asserted that such transference of authority to the administrators of the judicial powers saps the foundation of that rule of law which has been for generation a leading feature of the English Constitution. He says कि आप administrators को किसी भी type की judicial powers transfer नहीं कर सकते. If you transfer judicial powers to the administrative authority, then it is negation of rule of law. It is negation of equality. So here again I stop. If you have any question, you can ask. Now, third meaning of rule of law is judge-made constitution. And Dicey also explains judge-made constitution. He says that in many countries, there are several rights, such as right to personal liberty, which Indian constitution also provides under Article 21 of the constitution. Then there is freedom from arrest, and that also we have in our constitution. Freedom to hold public meetings, it is also there in our constitution. So he says that there are several rights like right to personal liberty, right from arbitrary arrest, right to hold public meetings. He says that these rights are guaranteed by a written constitution in many countries, and that is correct. These rights are guaranteed in Indian constitution as well, and Indian constitution is a written constitution. But he says that in England it is not so. In England these rights are not guaranteed by written constitution. He says those rights are the result of judicial decisions in a concrete cases which have actually arisen between the parties. He says that हमारे यहाँ ये rights एक written constitution ने नहीं दिए. ये rights हमारे यहाँ concrete cases में actually court ने लोगों के favor में decide किए, and that is why these rights belong to the People Act. They are not only found in a written constitution. Thus, Dicey emphasized role of the court of law as a guarantor of liberty, and he suggested that the right would be more secured adequately if they are enforceable in the court of law rather than by mere declaration of those rights in a written document, as in the cases of several countries. Because if you only mention those rights in written documents, in written constitution, he says these rights then can be easily ignored, they can be easily curtailed, or they can be easily trampled upon. So if you only mention those rights in written document, written constitution, then those rights can be easily ignored, easily curtailed, they can be easily trampled upon. तो आप ये rights ऐसे बनाइए जो कि courts में enforceable हो, सिर्फ उसको एक written constitution में लिख के ना रखें. He says that law of the constitution, the rules which in foreign countries naturally form part of a constitutional code, are not the source but the consequences of the rights of individuals as defined and enforced by the court. Actually देखिए, इंग्लैंड का तो written constitution ही नहीं है, और जब written constitution नहीं है तो generally ये rights court से ही judge होते हैं. Dicey further says there is in the English constitution an absence of those declarations, or there is absence of those rights and their definitions in the written constitution which are so dear to the foreign constitutionalists. So in short, our constitution or English constitution is a judge-made constitution, and it bears on its face all the features, good and bad, of a judge-made law. So he says that our is a judge-made constitution. हमारा constitution ऐसा नहीं है कि आप सिर्फ इसको एक document की तरह लेके पूजा करते चलें उसकी. Our rights are enforceable rights in the court of law. Ours is a judge-made constitution. Ours is not a written constitution. According to Dicey, mere incorporation or mere inclusion of certain rights in the written constitution is of little value in the absence of effective remedies of protection and enforcement. He further propounded that habeas corpus act, habeas corpus एक writ होती है already, और writ जो है habeas corpus का मतलब होता है कि कोर्ट किसी भी अथॉरिटी को, पुलिस अथॉरिटी को मेनली कहता है कि प्रोड्यूस द बॉडी ऑफ अ पर्सन विच यू हैव अरेस्टेड. तो यू कैन नॉट curtail anybody's liberty the way you want it, क्योंकि habeas corpus एक इसी तरह की रिट होती है. So he says that habeas corpus acts declare no principle and it does not define any right of the people, but these acts are for practical purposes worth 100 constitutional articles which guarantee individual their liberty. तो habeas corpus act हमारे यहाँ इंग्लैंड में कोई फंडामेंटल राइट नहीं है, लेकिन इसका इतना वैल्यू है कि सैकड़ों कॉन्स्टिट्यूशनल आर्टिकल से इसकी वैल्यू ज्यादा है, क्योंकि अल्टीमेटली ये किस चीज को इंश्योर करती है? इंडिविजुअल के लिबर्टी को. सो आई स्टॉप हियर फॉर 1 or 2 minutes. If you have any question you can ask. So friends, Dicey's thesis has its own advantages and merits. The doctrine of rule of law proved to be a very effective and powerful weapon in keeping administrative authorities within their limits. This doctrine of rule of law served as a touchstone to test all administrative action in the court of law. The broad principle of rule of law was accepted by almost all the legal systems as a constitutional safeguard. So Dicey's rule of law had its own good points, and the broad principles had been accepted in several legal systems as a necessary constitutional safeguard. तो इतना ही आपको करना है, क्योंकि ये क्वेश्चन जनरली 10 मार्क का आता है. इससे ज्यादा आपको कुछ भी करने की जरूरत नहीं है. रूल ऑफ लॉ में इतना सफिशिएंट है कि
दोस्तों, इस तरह के वीडियो को बनाने में काफी समय, मेहनत और रिसोर्सेस लगता है. आप अपना वैल्यूएबल फीडबैक जरूर शेयर करें ताकि एबनिशियो टीम को प्रोत्साहन मिले तथा आपके द्वारा दिए गए फीडबैक पर काम करके और इन्फॉर्मेटिव वीडियोस आप तक लाया जा सके. यदि आपको यह वीडियो पसंद आया हो तो प्लीज लाइक द वीडियो, सब्सक्राइब द चैनल एंड शेयर द वीडियो with needy one. Thank you for watching videos. Thanks a lot.